Legal and Privacy Brief for March 13, 2026. The FTC and 11 states reached a $100 million settlement with Walmart over Spark delivery driver pay misrepresentations. Law enforcement agencies disrupted SOX Escort, a cybercriminal proxy network that sold access to 369,000 compromised residential routers across 163 countries, seizing $3.5 million in cryptocurrency. The Ninth Circuit reversed preliminary injunctions against California's age-appropriate design code, rejecting NetChoice's broad First Amendment challenges for the third time. Here's the full breakdown of today's top legal and privacy stories. Next section, March 13, 2026. Next section, Enforcement Actions. Walmart $100 settlement resolves FTC driver pay lawsuit, case No. 3-26 CV 1655. The Federal Trade Commission and 11 state attorneys general reached a $100 million settlement with Walmart over allegations the company misled Spark delivery drivers about earnings since 2021. Regulators alleged Walmart misrepresented that 100% of customer tips would go to accepting drivers, when tips were actually split among multiple drivers for divided orders, reduced when combining batched orders, or paid out even when customers canceled tips. The complaint also alleges Walmart reduced base pay after drivers accepted offers and misrepresented incentive qualification criteria. The settlement allocates $10 million to the FTC, $11 million to participating states, Arizona, California, Colorado, Illinois, Michigan, North Carolina, Oklahoma, Pennsylvania, South Carolina, Utah, Wisconsin, and $16.2 million to a driver compensation fund, with the remainder suspended contingent on compliance. Compliance action: review gig worker pay structures and tip distribution policies. Implement earnings verification systems to ensure promised compensation matches actual payments. Audit incentive program communications for accuracy and track underpayments for correction. Sources: top class actions. Croatia DPA fines retailer Euros 6,636 for undisclosed video surveillance. Croatia's Data Protection Authority fined a retailer Euros 6,636. 14 for operating video surveillance in a shopping center retail branch for over 7 years without displaying required notices under Article 27(1) of Croatia's GDPR Implementation Act. The authority found 7 cameras installed since 2016 with no signage at the entrance, storefront, or interior. This was the retailer's second violation, having been previously fined on December 5, 2022, for the same infringement at another location. The DPA considered the maximum fine effective, proportionate, and dissuasive given the long duration, high foot traffic in the shopping center, and intentional nature due to repeat violation. Compliance action: audit all retail locations with video surveillance for proper notice signage at entrances and visible areas. Ensure notices comply with Article 13 GDPR information requirements. Document installation dates and previous violations to assess exposure. Sources: GDP Rub 05/1/2026. Spain DPA fines age verification provider Yoti Euros 950,000 for biometric processing violations. The Spanish Data Protection Agency fined Yoti Limited Euros 950,000 for unlawfully processing biometric data and failing to limit data retention. Yoti Digital Identity and Age Verification Services process facial recognition data, which the EAPT classified as biometric data under Article 9(1) GDPR. The authority found Yoti bundled consent for identity verification with consent for research and development purposes into a single request, violating Article 7 GDPR requirement for freely given, specific consent. Users could not refuse the research processing without losing access to the service. The authority also found retention periods exceeded necessity requirements under Article 5(1) GDPR, with identity documents and selfies retained up to 28 days, and digital ID app data stored for 3 years of inactivity. Compliance action. Separate consent requests for distinct processing purposes. Do not bundle service essential processing with optional purposes like research. Review biometric data retention schedules to ensure compliance with data minimization requirements. Document legal bases for each processing purpose separately. Sources: GDP Rub Exp 200 2,317,887. Arizona AG secures $212,000 settlement over greenwashing recyclable bags. Arizona Attorney General secured a $212,000 settlement with Reynolds Consumer Products over allegations the company misleadingly marketed hefty recycling bags as recyclable when Arizona municipal programs do not accept them. The complaint, filed in August 2025, alleged the packaging used the word recycling and images of bags filled with recyclable items, inducing environmentally conscious consumers to pay premiums for non-recyclable products that could damage recycling facility equipment. The settlement requires $30,000 in consumer restitution, $80,000 in nationwide packaging redesign costs to remove recyclable images, and add "these bags are not recyclable" front panel disclaimers. Consumers who file complaints by October 1, 2026 receive proportional shares of the restitution fund. Compliance action. Review environmental marketing claims for accuracy against local and state recycling program capabilities. Remove imagery suggesting recyclability where products are not widely accepted. Add clear negative disclaimers to prevent consumer deception. Sources: top class actions. Law enforcement disrupts SOX escort network. Seizes $3.5 M cryptocurrency. The Department of Justice, FBI, and Europol disrupted the SOX escort residential proxy network, which sold access to approximately 369,000 compromised IP addresses across 163 countries from 2020 to 2026. The operation seized 34 domains, took down 23 servers across 7 countries, and froze $3.5 million in cryptocurrency. SOX escort used AV Recon malware to infect approximately 1,200 router models from Cisco, D-Link, Hikvision, MikroTik, Netgear, TP-Link, and Zyxel, selling access to cybercriminals who concealed their locations while conducting fraud schemes including unemployment insurance fraud, cryptocurrency thefts, and bank account takeovers. The platform netted over $5.7 million and maintained an average of 20,000 distinct victims weekly. Law enforcement agencies in Austria, Bulgaria, France, Germany, Hungary, Netherlands, and Romania participated in the investigation beginning June 2025. Compliance action: patch vulnerable routers immediately. Monitor network traffic for unusual proxy activity or unauthorized access. Review router models against the FBI flash alert for AV Recon malware targeting. Consider replacing end-of-life devices lacking security updates. Sources: The Record. Next section, Litigation Updates. Ideal Image $3.5 M Web Tracking Class Action Settlement, Case No. 25 CA 011075. Ideal Image agreed to pay $3.5 million to settle claims. It used Metapixel to collect and share sensitive consumer data without consent from visitors who scheduled consultations on Ideal Image. Between January 1, 2023, and January 26, 2026. The complaint alleges the company failed to inform consumers their information would be shared with Meta Platforms Inc., and did not obtain consent before sharing data with Facebook and Instagram's parent company. Class members who submit valid claims by April 27, 2026 can receive cash payments up to $17, subject to pro rata reduction based on claim volume. The settlement also requires Ideal Image to suspend collection of sensitive information through web tracking. Final approval hearing is scheduled for June 17, 2026, in Florida's 13th Judicial Circuit Court. Compliance action. Audit website tracking pixels and third-party scripts for data collection and sharing. Provide clear disclosure before collecting sensitive information like medical consultations. Obtain affirmative consent for sharing data with advertising platforms. Review cookie consent mechanisms for CCPA and state privacy law compliance. Sources: top class actions. Lenovo class action claims data sharing with China. Case No. 3-26 CV 1133. Plaintiff Spencer Christie filed a class action against Lenovo alleging violations of the Electronic Communications Privacy Act, California Invasion of Privacy Act, and unfair competition law for sharing U.S. consumers' data with China. The complaint filed February 5, 2026, in California federal court alleges Lenovo violated a Department of Justice rule implemented in April 2025, prohibiting transfer of Americans' bulk, sensitive personal data to countries of concern, including China. Christie claims Lenovo intercepted full-page URLs, product views, persistent identifiers including IP addresses, advertising ID, and cookie data when he visited Lenovo's website to purchase a gaming computer, then transmitted this data to covered persons without required safeguards. The lawsuit argues this enabled Lenovo and its foreign parents to link browsing activity to identity and build detailed behavioral profiles. Christie seeks class certification for anyone whose communications with Lenovo's website were intercepted and whose data was used on or after April 8, 2025. Compliance action. Review third-party data sharing practices for compliance with DOJ rules on bulk-sensitive data transfers to foreign countries. Audit website tracking implementations for interception of communications and persistent identifiers. Document safeguards for international data transfers, particularly to China, Russia, Iran, North Korea, Cuba, and Venezuela. Sources: top class actions. Figure lending data breach class action, Case No. 3-26 CV 135. Plaintiff George Mardikian filed a class action in North Carolina federal court, claiming Figure Lending, LLC, failed to adequately safeguard customer information during a February 2026 data breach. The complaint alleges Figure Lending failed to train employees on cybersecurity and maintain reasonable security protocols, rendering customer personally identifiable information vulnerable to cybercriminals. The breach resulted from an employee falling victim to a social engineering attack that allowed hackers to steal files containing customers' full names, home addresses, dates of birth, and phone numbers. Mardikian claims Figure Lending is guilty of negligence, breach of implied contract, and violations of the California Consumer Privacy Act and California's unfair competition law. The plaintiff seeks declaratory and injunctive relief plus compensatory, exemplary, punitive, and statutory damages for himself and all class members. Figure Lending offered credit monitoring to some victims, which the plaintiff alleges is insufficient to compensate for injuries. Compliance action. Implement mandatory security awareness training focused on social engineering and phishing. Establish multi-factor authentication for file access. Conduct incident response tabletop exercises. Review data breach notification obligations under state laws and offer appropriate remediation beyond credit monitoring. Sources: top class actions. The court found the articles defamatory and affecting the judge's professional reputation and dignity. The court also ordered Microsoft to communicate the logic behind Bing's search algorithm, specifically related to how content from Luju row involving the data subject is prioritized in search results, and to provide records of processing activities under Article 30 GDPR and data protection impact assessments under Article 35 GDPR. The court held Microsoft wrongly concluded judges are public figures justifying refusal to remove contested articles. While accepting the data subject is a public figure, the court found the false and defamatory character meant the right to private life and data protection took priority over the right to be informed. Compliance action. Establish procedures for evaluating right-to-be-forgotten requests from public figures. Do not automatically refuse removal requests based on public figure status. Conduct balancing tests between rights to information and rights to privacy. Document algorithmic logic for search result prioritization to comply with transparency requirements. Sources: GDP-RUB. Next section, Regulatory Guidance. FBI increases Section 702 searches by 35% in 2025. FBI searches of Americans' data in the Section 702 Foreign Intelligence Database rose 35% to 7,413 queries between December 2024 and November 2025, up from 5,518 the previous year, according to a March 11 letter from FBI Acting Assistant Director Ted Groves. The increase reverses years of decline from 2,964,643 searches in 2021 to 57,094 in 2023. Only 28% of 2025 queries returned Section 702 acquired information, down from 38% in 2024. Section 702 allows the NSA to collect foreign intelligence from international communications of terrorism suspects, hackers, and foreign spies overseas, but also intercepts Americans' data. The Surveillance Authority expires April 20, 2026. President Trump has requested an 18-month clean extension. The disclosure could reignite debate over warrant requirements after previous revelations. The FBI used the tool to search for information about January 6 defendants, George Floyd protesters, and a House Intelligence Committee member. Compliance action. Monitor Section 702 reauthorization developments for potential warrant requirements affecting government data requests. Review law enforcement data request procedures for documentation of legal basis. Prepare for potential changes to lawful access frameworks. Sources: The Record. UK regulators demand social media platforms strengthen age assurance. By April, the UK Information Commissioner's Office and Ofcom published warnings demanding Facebook, Instagram, Snapchat, TikTok, YouTube, and other large platforms integrate robust age assurance tools by the end of April 2026. The regulators found many platforms set minimum ages of 13, but rely solely on self-declaration, which is easily circumvented, allowing underage children to access services not designed for them and putting them at risk of unlawful data collection without entitled protections. The ICO said it has started direct engagement with highest-risk services and expects them to strengthen age assurance measures over the next 2 months. Ofcom will make companies' responses public in May and announce regulatory action. The regulator's research shows 72% of children aged 8-12 access the platforms. Ofcom's 4 demands include effective age assurance protocols, fail-safe grooming protections, safer feeds, and no product testing on children. Compliance action. Implement age assurance technologies beyond self-declaration. Consider age estimation, identity document verification, or third-party age verification services. Document age assurance effectiveness and accuracy. Review child safety features and default settings for users under 13. Prepare responses to regulator demands if operating in UK markets. Sources: The Record. Romania DPA warns against facial recognition for employee access. The Romanian Data Protection Authority warned Arise Live SRL that implementing a facial recognition system for employee office access could breach Article 5(1) A GDPR lawfulness, Article 5(1) C GDPR data minimization, and Article 6 GDPR legal basis. The DPA found the context did not meet requirements of legality, necessity, and proportionality for biometric data processing, particularly since the company already used an access card system. The intended facial recognition system was designed to prevent unauthorized access and misuse of access cards. The DPA recommended using less intrusive measures that do not involve biometric data processing and warned that implementation could infringe the right to private life and data protection. Compliance action: evaluate necessity and proportionality before implementing biometric access controls. Consider whether existing access systems, cards, PIN, keys, adequately serve security purposes. Document why less intrusive measures are insufficient if proceeding with biometrics. Conduct data protection impact assessments under Article 35 GDPR for high-risk biometric processing. Sources: GDP Rube warning against Arise Live. Next section, privacy developments. Ninth Circuit allows California Age-Appropriate Design Code to precede the Ninth Circuit reversed, in large part, the preliminary injunction against California's Age-Appropriate Design Code, delivering the court's third rebuke of NetChoice's litigation tactics. The three-judge panel criticized NetChoice for repeatedly lodging broad First Amendment challenges to regulations without providing legal analysis or evidentiary support required under the Supreme Court's Moody v. NetChoice decision. The ruling allows parts of the California law regulating online services design features affecting minors to go into effect. Epic filed an amicus brief defending the law against NetChoice's constitutional challenge, claiming tech companies' use of surveillance data and addictive feeds is protected speech. Compliance action: review online service design features for compliance with California's Age-Appropriate Design Code if targeting California users under 18. Assess data collection, processing, and sharing practices for minors. Implement privacy by design and privacy by default settings for child users. Document necessity for processing minors' data. Sources: Epic. Maine Senate passes strong privacy bill. The Maine Senate passed the Maine Online Data Privacy Act, LD 1822, which closely mirrors Maryland's 2024 privacy law and would extend comprehensive privacy protections to Maine residents. The bill is proceeding through the legislative process. Compliance action: monitor LD 1822's progress for potential compliance requirements if serving Maine consumers. Review existing state privacy law compliance programs for Maryland model elements. Prepare to extend consumer rights, access, deletion, opt-out to Maine residents if enacted. Sources: Epic. DOJ demands sensitive voter data without adequate protections. Epic raised concerns that the Department of Justice is demanding sensitive voter data without committing to adequate data protection measures. The advocacy group warns this could enable voter suppression efforts ahead of midterm elections through control of who votes. Compliance action: document legal basis for providing voter registration data to federal agencies. Review data protection agreements and security commitments before transferring sensitive voter information. Consult with state election officials and legal counsel on disclosure obligations and limitations. Sources: Epic. Next section, policy changes. OpenAI. Pentagon deal raises surveillance concerns despite amendments. OpenAI